misdemeanors for official oppression. That was it's in Chapter 39, Texas Penal Code. It wasn't for any of the things that y'all had listed. It was for that the indictment read for unlawfully detaining two people, namely Landon Goad and Sarah Johnson, beyond 48 hours when no probable cause had been found by a magistrate. So some things you need to understand about the magistration process. One, I'm not a magistrate, right? And at the time, we only had a single person doing the magistration and doing the bondings, and that was Judge Swenson. On occasion, we would call Judge Campbell in to do that when Judge Swenson couldn't, but for years and years, he's been coming up and doing the magistrations and the bonding. And it was no different this weekend. Sarah Johnson and Landon Goad were both arrested for assault, family violence. Both of them pointed the finger at the other one as to how they got injured, and both of them had visible injuries on their person when our deputies showed up. They had conflicting stories about who started the incident, so our deputy, in accordance with the Code of Criminal Procedure and the rules concerning family violence, arrested them both and brought them to the county, arrested them at 11 minutes after 3 and brought them to the county jail. Come on in, Renee. Judge Swenson was notified Saturday that they were in the jail. Judge Swenson came to the jail on Sunday and did in fact magistrate two other people out of the jail on Sunday when Sarah Johnson was sitting in the holding cell 5 feet from him. He was aware that both of them were in the jail, and he was here on Sunday magistrating people, and he failed to do so. He did not return Monday morning to magistrate anyone, but did come in that afternoon. I think it was somewhere around a quarter till, the jail administrator has the exact times. I believe it's around a quarter till 2 on Monday. And this is important and germane to the discussion because that's when I found out they were in the jail. I was actually in Fort Worth that weekend and not here nor in the jail, nor was it my responsibility to magistrate or bond them at that time. Around 2 o'clock in the afternoon, I was contacted by my chief deputy, who brought me the magistration form where it said no probable cause. My first question was, had the judge released them or given an order to release them because of that, and he had not. So our only alternative was to contact him and get him, find out what it was that he didn't like about the affidavit. Was the probable cause not there? Were the elements of the offense not there? Did he not like the wording? Whatever it was. He explained to us what it is that he changed it, and we altered those things on the probable cause affidavit. And he was contacted again. He was contacted again at a quarter till 2 or a quarter till 3 on Monday to come back down, which he failed to do. The next morning, on that Monday, in my mind, the problem was there and solved. We had fixed the probable cause affidavit as per his instructions and notified him that they were available for magistration and for the PC, and it was within the 48 hours, and he failed to come back. So in our minds, the problem was solved, and we didn't address that again until the next day. So that's exactly how this thing came about. And that, based upon that information, is where the indictment came from. So if you've got questions to ask, I'll be happy to try and answer them for you. But what I'd like to do, if we can, there's not a lot of reporters here, but if I'd like to, if we cannot, shout over people, I will answer your questions until we can. I don't want to turn this into some White House briefing thing. And Trish, since you're the only female reporter here, tell me what you would like to ask. I'll let you go first.
Yeah, I just want to make sure I understand. You're
Sure.
saying that Justice of the Peace John Swenson did not magistrate the two people, Sarah Johnson and Landon Goad?
That's exactly what I'm telling you. So when people get put in jail, you have to have a document as you well probably know, we can't just go latch people up off the street and throw them in jail. You have to have a document to put them in the jail, and you have to have a document to release them from the jail. It's in the Administrative Code under the Texas Commission on Jail Standards Rule, Chapter 9, 237 maybe, read? Yeah, I think that's right. But you can call back up here and the jail administrator would be happy to tell you exactly where it is. You have to have a document to release them from the jail as well. And that document is either a magistrate's order of release or an order of release or a bond or a bail. You have to have something, according to the jail commission, you have to have something to put in their file, and you have to keep it on file in perpetuity, showing that you had a reason to release them. Physically, I can go to my office and go get the brass keys and unlock all the doors and run everybody out in the street. Physically, I can do that. Legally, I cannot. So when they come in for quote-unquote magistration, the finding of the probable cause or not is irrelevant. A magistrate can find no probable cause, and we can turn around and file it directly with the county attorney or the district attorney, and they either take it or they don't. But the bonding, the release document, is what has to be done, and it simply wasn't done. It was not done Sunday. He was notified Saturday. He came in on Sunday and released 2 other individuals. Then he came back on Monday and again did not release them from the jail.
So you're saying it's Judge Swinson's fault that the people were held for over 48 hours without a finding of probable cause?
I'm saying that it is his job to sign the releases, and he failed to do so. That's exactly what I'm saying.
So you're saying he did not sign orders to release them from the jail?
That's correct.
Okay, because he sent some PCs that he and said he had magistrated them at the jail.
The magistrate's form.
But he didn't get copies back from the jail.
That's just simply not true. If he had signed the magistrate's order, in the middle of the magistrate's order, there's a thing in the center of it that says what the bail or the bond amount is, or whether it's a PR bond or whatever, and it's an order to release them.
Okay. Well, your office actually sent me copies of the new affidavits that were done and went before Judge Campbell. So what? I mean, they're different looking. I mean, they're different because it's. Did you see the one prior to and then the one after? Yeah.
What did you think was different about them?
Just that he didn't seem to say, well, I couldn't figure out who was telling the truth, so I arrested both of them. That was the basic thing. That's correct. The deputy said in the previous affidavits, but I mean, don't they have to be released from jail if they're more than 48 hours? I mean, don't they have to be released?
Well, the question is, doesn't someone have to sign the release? Yes.
So you can't really, you're saying you do not have the power to release them from jail?
That's not what I'm saying. I'm telling you what I knew then. As a result of this whole fiasco, I contacted Seth Slagle, our county attorney, and he in turn contacted the Texas District and County Attorneys Association to research and find out. I don't know if you ever heard about what's called the sheriff's bond. Because there is no bail bonds board in Clay County, it makes me the bail bonds board, and I can take bond from anyone, including myself. So what I do is now, on all the misdemeanors and state jail felonies, I don't tend to do the bonding on the big felonies, and for personal reasons, I cannot put a bond of more than $10,000 on a felon. And I don't want a murderer or some serial rapist getting out on a $10,000 bond. So I leave those to the judges who can set higher bonds on those kinds of people. But as a result of this, Seth Slagle and the Texas District and County Attorneys Association drew up the form, and it's now on our letterhead, and I do sheriff's bonds on all the misdemeanors so this never happens again. So we actually had to change the way we do things. But at the time, it's not about what I know now, it's about what I knew then. And what I knew then is that he's the guy who does the magistration, and he's the one that signs the release orders.
Is Seth Slagle here?
I doubt it.
Okay.
I don't
He's
see him.
very elusive. I'm trying to get him serious. I mean, anytime.
Well, be careful. You know, we're streaming live here. He may become more elusive now.
Well, yeah, I could, but, okay, well, so what happens from here? I mean, have you contacted Staley Heatley and told him what you're telling us, or?
Staley Heatley contacted my attorney, and I think his words were, we are finished with our investigation. Would you like to talk to us? Well, if you put it that way, no, I don't need to talk. You already made up your mind what you're going to do. Why would I need to talk to you? I was never contacted directly by any investigator or the DA until they told me that they had completed their investigation.
Okay.
What you got, Martin?
Well, a couple of things. I think you've told me before, but how much longer were they in the jail before they got released? Was it Tuesday morning?
They got out, so Tuesday morning, that was the thing, when, as the timeline goes on, after Monday, every morning I walked the jail during the week. So I walked the jail that day, and there was Miss Johnson still in the tank right next to the booking desk. And that's when the jail administrator told me that Swenson had called and said he wasn't coming. After he told me he was, he called me and told me he wasn't, and he was going to call Mike Campbell to come. And Judge Campbell denies ever receiving a phone call. So when I came in that morning and I saw her still there, my first call was to Judge Campbell's office. Becky Mataska, y'all remember, she said he wasn't there, and I called him on his cell phone. And not to cast any bad light on Judge Campbell whatsoever, he didn't realize he needed to be there, and he had already gone to do something else. So he didn't, I think it was around 1, is that right, 1:30 when they finally came out on Tuesday?
Yes.
And they were magistrated and probable cause found on the shortened version of the affidavit, not the longer version that you had before. And if you didn't ask, but if you're curious as to why that statement is in there, so in Texas, where we currently are, you have the right to defend yourself. And if someone comes up and physically attacks you, you have the right to defend yourself. It's in Chapter 9 of the Texas Penal Code, specifically 9.31. You can defend yourself against an attack. Therefore, one of the two of them would have had a Chapter 9 self-defense. They would have a defense to the offense we were writing them for. If he could have determined who the primary aggressor was, he would have just taken that person. But because they both exhibited injuries, they were both bleeding, and they both pointing the fingers at each other, he had to take them both. And then he's got to justify to the chief and I and to our investigator why he took them both. That's why that statement's in there in the first place. The second affidavit is actually defective, if you ask me. The one without that statement in there is defective because now we've opened up a defense to prosecution because we failed to eliminate that defense from our affidavit.
Well, let me get this straight.
What you got?
So you're saying Judge Swenson indicated that he would contact Judge Campbell,
Yes,
but Judge Campbell said he never got a phone call about it.
that's correct.
Okay. And exactly how did these indictment charges against you get brought about? Who brought them? Where did they come from?
My understanding is the complaint was signed by Judge Swenson. Now, we have not received, the prosecution has not delivered the discovery to us, so I don't know who actually signed the complaint.
Okay. But
I know my attorney asked for it a week ago.
how long after this whole incident did a complaint get filed?
I can't tell you because I don't know. I don't have the paperwork.
Okay.
Yes, sir.
Have you ever had a justice of the peace do something like this in your career ever?
No, wait, I'm sorry, I don't know you. I'm calling in by the first.
Michael Grace with News Channel 6.
Oh, okay, KUZ.
Yes.
They got to give you that plug there,
There you go.
KUZ.
Appreciate it.
Well, and I'll tell you, I appreciate KUZ. I really do. The only news outlet that ran anything on here that did not run unverified information. So, I appreciate KUZ and what you're doing over there at Channel 6. Question reference to, have I ever had this thing before? I'll be honest with you. I got out of the DPS Academy in 1998. Standing in this room is probably over 100 years of law enforcement experience, thousands, tens of thousands of affidavits. I've never seen this before. I've never seen this kind of behavior at any time on an affidavit, because it's standard practice. I know it's just standard practice. Even during the digital age, it was standard practice to put a thumb drive in your pocket. So when you ran down there with the hard copy, if the judge didn't like the way you worded it, you could go plug it in, change it right there, and then print it right back off. Now, y'all did it at APD, Kenny?
Yes, sir.
Austin PD. It was, if the elements of the offense are there, and every judge looks at them a little differently. So, I was with DPS in Austin and also in Waco and down in Guadalupe County, but the Highway Patrol works big swaths, so I might have had to do affidavits. In McLennan County, we had 9 justices of the peace, 2 of them downtown, 2 of them just in downtown Waco. So, depending on where you were when you wrote the affidavits, what might work in JP 1 place 2 wouldn't work at all up in West, with the JP up there. So you would have to go in there, and the thing about those affidavits, they're probable cause affidavits. It's not courtroom testimony or beyond a reasonable doubt. It's did it more likely occur than not. So all you're writing are the elements of the offense. And the elements of the offense in that particular case it was assault, family violence with injury. So, you can obviously, they have to be defined as family in the family code, right? Cohabitating or used to cohabitate, or, relatives by blood or by marriage. You have to have that, and then that's there. They have to have injuries, and they have to be caused by somebody else. That's all that needed to be written in there, except for the fact that we needed to get around the self-defense clause in Chapter 9. So it's just like a DWI. Is intoxicated, is operating a motor vehicle in a public place. That's all that needs to be on a DWI case. The rest of it is superfluous. Some judges want more, some judges want less. In this case, this judge just told us that we needed to take, initially said it didn't say intentionally or knowingly, which it did, and then he didn't like the fact that we were getting around Chapter 9. I don't know why, but that's not how he wants it written is not what I haven't seen before. The fact that he wrote no probable cause and then ducked out and ran out of jail and didn't tell anybody, that's the problem.
So you've never seen anything like that?
Never.
Is there going to be any repercussions against Swenson for doing
That's not up to me. I try really hard not to get in other elected officials' business. I do what I do here at the sheriff's office, and I've developed a really good team. We see a whole lot less crime around town. We used to carry between 15, 20 people in the jail all the time with frequent flyers that were in and out, in and out. Where'd they go? I don't know. But they're not here anymore. And if they are here, we're not having to put them in jail anymore because they're doing what they're supposed to be doing. We've brought an aggressive approach to law enforcement here to Clay County, and it's all over town. When we first took here, we had jail full most of the time. Now I think if we have more than 12, it's a big day.
Questions.
What you
I have
got,
more
Trish?
questions. Who's your lawyer? What is your name?
Randall Moore.
Oh, okay, hi, thank you. Nice to meet you. And then there was something all over Clay County ransom raids, and we don't print Did Sarah Lynn Johnson try to kill herself while she was being held in jail for that?
That's not, that,
We can't release that.
that's not information that I can release. There's a whole bunch of problems with talking about what does and doesn't happen in the jail, especially with regards to any sort of medical attention. So if she did and she received medical attention, then that would be a HIPAA problem for me, and I'm just not getting involved in that.
So you won't even tell us if she was on suicide watch or
That would violate
special
HIPAA.
testing?
Yeah.
You'd have to do an open records request to get that information, and
Okay,
so.
I will do that, thank you.
I have
And
no
then,
doubt.
I guess I might take a little issue with you saying we printed unverified information because I did ask you for comment, and I always do. But if you don't comment, then what am I gonna do? I mean, my hands are tied.
No, they're not.
Yeah, they are.
KAUZ didn't. I'm telling you that I was sitting at my desk, drinking a cup of coffee, checking my email, when I got a text saying, you need to check Facebook.
Uh-huh.
And from my desk, I learned that I had been chased down and arrested by troopers, was being held in one of my own cells. I was held without bond, currently in my own jail. That's what I got that from news outlets at my desk when I was sitting there checking my emails.
I didn't write any of that.
I didn't
And
say
that's
you,
why I'm
Trish.
saying, hey,
I didn't
hold on a
say
second.
you, Trish. I
Okay.
didn't say you. I said the news outlets published things that were simply not true. And that is a fact. That's not subjective. That's factual information. I was sitting at my desk when the story broke that I had been chased down by troopers and was currently held without bond in my own jail. It's just simply not true.
And these were from news outlets, not just Facebook posts by random people.
Texoma's homepage is the one that
Oh,
broke
really?
that one.
Okay.
hmm
Someone's-
But that's also a little problem too when it goes there and then it comes somewhere else and then y'all use each other for sources.
No, we don't use each other for sources.
Okay.
I don't use other media
Okay.
outlets. If I do, I credit them and say according to the
Mhm.
media
Yeah.
outlet, but no, that's.
So the paperwork had to be processed.
Mhm.
So rather than keep the judge, and there weren't any troopers, there was a ranger out of Wichita Falls who walked across the street and came back, and we coordinated the date and time. And the jail administrator, because she wasn't going to hang up these people in there, was doing all the processing, but she didn't have the documentation to finish the process, and she hit suspend on the thing. It posted to our jail roster, and then next thing you know, people were screenshotting that. It didn't say held without bond, it said no bond. It didn't say held without bond like it was printed, it said no bond because we didn't have it yet to put in the space. Now I think if she knew then what she knows now, she probably would have just left it on the screen and waited. But we've learned a lot of things, in this, like the sheriff's bonds. We've learned how to do a whole bunch of things new because of this.
So now what?
What else?
Yeah, now what? Now with the indictments and everything, what's the next step?
The next step is to get the discovery from the district attorney and plan to see what they're going to do. That's kind of ball in their court kind of deal.
So I know it's not the 97th district, it's 46.
It's absolutely the 97th district. Our district attorney, Casey Paul Hemus, appointed. He's Staley Heatley. Staley Heatley. She appointed him as the district attorney pro tem for this case. So yes,
Yeah.
he is out of Will Barger County, but
Yeah.
he's working on behalf of the 97th.
Okay.
Yeah, because the case is on file here in Clay County.
Okay, so
So the
that
DA,
was her decision, I know,
So-
because she sent me a press release and everything.
the
saying-
pro tem DA will come here to
Okay,
handle the case. The documents, I'm assuming, are going to be filed here.
so you can't do anything until you get the document, y'all haven't gotten any documents yet, or
We got copies of that, but what we need to see is
discovery?
the information that they use to get these indictments on, specifically, what evidence do they have that proves that he intentionally detained somebody knowing he was violating their rights when he didn't know that they were in jail and was in Fort Worth.
Okay,
So that's kind of what I'm interested in seeing, and
Oh, I'm sorry.
we'll have further comment when we see the file.
This is I'm sorry. This is an unusual charge. If you read it, 3902, 3903, it's official approach. Anyway, the first line it'll say, and all things in the penal code will say it. Person commits an offense if : right? So that's what it says, and then it'll say, person commits an offense if, and in this particular case it says intentionally subjects someone to one of these enumerated things, knowing that the action was unlawful. So you can actually intend to do the thing and not know it's against the law, and you still can't make the case. What I'm telling you is, I didn't even know they were in the jail till Monday. They were arrested on Saturday. I was in Fort Worth. I come back on Monday. How am I to know that they're in the jail? Yeah, I have really good people working for me. You know, I have outstanding people, and we did it that way on purpose. There's an air of professionalism and difference around here that wasn't here before. Not so much because of me, but to the people that I reached out to come in here to work. We've got a guy that was a detective in APD for more than a decade, got 25 years on down there in Austin PD. My chief deputy has worked undercover narcotics. He's been in homicide. He worked K-9. He worked SWAT. I mean, there's a tremendous amount of experience around here. You know, my jail administrator is not just a jail administrator. She's a master jailer, and she also is a master telecommunicator. She runs both the radio room and the jail. She's a wealth of knowledge, and furthermore, we got inspected by the jail commission in November, who reviewed all of these records, and we passed with not even a flaw. The Texas Commission on Jail Standards didn't have a problem with what we did, and they're the regulating body that controls it. So we do need to know, how do I, in another area code, know that someone's being held or intentionally hold them, knowing it's unlawful when I don't even know they're in the building? How does that happen? I think that's part of that we can indict a ham sandwich thing you've heard on TV. And I think I'm the ham sandwich.
I have some questions that are not
Come on.
related to this.
Okay, what you got?
Sure, okay. Well, you know, Rolling Stone splashed it everywhere that you're turned up in an Oath Keepers database as a
Mhm.
member. And so, is that true, or?
Well, I'll tell you about it. I'm glad you asked. That was, we were talking about there. I was really hoping that this would be a thing. So, I don't know. I would have to say maybe 10, 12 years ago. I don't really remember exactly, but it was probably 10, 12 years ago. I was a sergeant in Texas Highway Patrol down in Seguin. And they had this new group, it's called the Oath Keepers. And the Oath Keepers at the time were nothing but police officers and former military people. Mm-hmm. And as you may or may not know, I'm both. I'm not just a master peace officer, I'm also a master parachutist and a combat veteran out of the United States Army. So I'm both. So the oath that you take, or are required to take under Article 6 of the United States Constitution, means something to me. Every one of you in here has been written a check signed by me for a blank check up to and including my life in your protection. And I jumped out of moving aircraft while in flight. It's not just something I take lightly, it's something I'm serious about. And at the time, that is what the Oath Keepers was about. As with any organization, I remember, I think it cost $1 to join, and you got this sticker that looked like a Ranger tab, the Army Ranger tab, right? And a hat or a T-shirt or something. And that was my last involvement with them. I don't know if they have meetings. I don't know what it is or what it isn't. I don't know what they did or didn't do, or what certain members did or didn't do, but therein lies the problem. We categorize and we put people into things, and then we call them a name, and we try to make it stick. I get actual death threats. Got one today. Got 2 yesterday. Because Rolling Stones decided they would tell everybody that I was some kind of white supremacist. Which is odd, because they also called the lieutenant governor in Virginia a white supremacist, and the mayor-elect in New York City a white supremacist, and both of them are African American. It's not about the color of your skin, it's about the culture and what names people can associate you with. If there were people on the 6th, on January 6th, that went into the Capitol, if some of them happened to be Oath Keepers, I doubt very seriously every Oath Keeper would condone that, and I certainly don't. But you know what else? I also don't blame every BLM member for the fires in Kenosha. I don't blame every Antifa member for the stuff up in Seattle. And I don't blame every Muslim for 9/11. So did I give them, $1, $5 12 years ago and get a sticker that was on a truck that I don't own anymore? Yeah, absolutely true. If that makes me a member of the Oath Keepers, then so be it. I will tell you that I am an Oath Keeper in the sense that I will never subject you or anybody else in Clay County to things that are unconstitutional. You'll never see me chaining churches. You'll never see me interfering with your right to move about peaceably and peaceably assemble. So if that makes me an Oath Keeper, then yeah, I am.
Would you join that organization today?
I don't know that I would join that organization today, but not because I don't think the basic principles of the organization are sound. Like, for example, I do think Black Lives Matter. I absolutely do. Do I think that every member of Black Lives Matter is some militant that walks down the street with a machine gun or setting businesses on fire? Absolutely not. And I'm not going to blame the entire whole of them for the actions of a few, and I don't think that you should either, or anybody else.
Okay, thank you.
You bet. Y'all got anything you want to know? Nothing?
I've got this one.
Come on, Trish.
Unrelated
Okay.
to this. Could you maybe talk about under what circumstances you left the DPS?
What circumstances I left DPS? Yeah, I was having not a really good time down there in Seguin. I had a supervisor. I'm not going to mention his name because I'm just not going to do that. I had a supervisor that I did not get along with at all. There were many times that we got crossways in different discussions, heated discussions, and I no longer liked going to work every day. I just didn't do it. And then one day in his office, I said something that was exceptionally insubordinate. It was a violation of probably half a dozen of the 10 general orders, what I said to him. I'm not going to repeat it here, but I said something I shouldn't have said, and I knew that I needed to go find another job because it was just a matter of time. I was already vested in the defined benefits program. I already had my retirement locked down, and I went looking for a job, and within a week I found a job that paid me twice the number of what it did being in the highway patrol working for an oil company. And so rather than give them the opportunity to try to fire me, which he should have done because I'm telling you right now, I had it coming. I needed to go. It was a shame with regards to I love the troops that that worked for me. I'm still in contact with almost all of them. I probably have more troopers that worked for me that are now Texas Rangers than any other highway patrol sergeant in the history department. I think last time I looked, it was more than half a dozen of them that worked for me that are now Texas Rangers. I thought we did a really great job down there in Seguin, but I let my youth and hot-headedness kind of overrun me there, which was another good lesson for me that day.
What year was it that you resigned?
2012.
Okay, thank you.
Sure.
So you're still going to have to work with Judge Swinson. So how are you guys going to work together with all this conflict?
Well, that's entirely up to Judge Swinson. I don't know why. I just know that I can't tell you why. I'm not going to speculate on why he went and signed that complaint. You guys can figure that out for yourself. Or you can go talk to Judge Swinson and ask him about that. You can ask him, why were you there on Sunday 5 feet away from one of these people and didn't do a release order on him? Why did you not sign the magistration order, if not to find probable cause, just to let him out of the jail? Why didn't you do it Sunday? Why didn't you do it Monday? Why didn't you talk to the jail administrator as you walked by her and say, like you have done every other time, and said, hey, there's a problem with this PC affidavit? That's questions for him to answer. As far as working, quote unquote, with Judge Swinson is the Justice of the Peace, and he handles inquests on bodies as per Chapter 49 of the Code of Criminal Procedure. He sits for all Class C fine only misdemeanors, traffic tickets, things of that nature that we write. And what he does over there with those traffic tickets is entirely up to him. I'm not going to tell him how to do his whatever, and if he wants, he can dismiss them all, or he can prosecute them all, or he can do whatever he wants to, because it's none of my business what he does in JP's office. I'm concerned about this building. And how we eliminated the conflict in there was to, again, go back to the county attorney, seek his guidance on how to do sheriff's bonds, so we eliminate that from the process.
Thank you.
Sure. Come on, Martin. No? That's it?
I've got a deadline.
Oh, okay. Well, I don't want to run you past your deadline. And I wanted to get you guys in here early enough where y'all could go back and do whatever it is y'all going to do back over in Wichita. You got me? I got a countywide fire meeting at 6 o'clock, so y'all, I got till 6. You just let me know if you still want to ask questions.
Well, is there anything we didn't ask you that you?
There you go.
Yeah, that's, wow, under leading, see her. When you look up.
We'll probably have further comment when we see the file.
When we get the file and the discovery, I'll be happy to have you guys back over here.
Do we have a timeline on that or anything? Y'all know?
The DA's been very cooperative with me on that. I think the email I received last week was that there were, his office was tied up with a bunch of pre-trials, and that he had to take care of that stuff before he would get me the file. He was going to give it to me without me having to even file a formal request, so
Yeah.
he's going to get it to me as soon as he can. I have no concerns about the timing.
That was a big number too. It was like 67 or 87 something cases.
He had a lot
It
of
was huge.
pre-trials he was working on, so I have no concerns about the timing on the file. When we get the file, we look at it, and we find out,
Yeah.
the intent issue, then we'll know where we're at that point in time.
And your name's Randall Moore, Randall,
Yes, sir.
Moore?
Correct.
Easy enough. So once all that gets done and everything, we'll know more.
Yes, sir.
Okay. And I guess the last question is, now, if, I know you don't think these charges will stick, probably be dismissed or something, but if you get convicted on these charges or whatever it is, will you have to resign being sheriff?
Yeah, I don't really know, and I wouldn't even hazard a guess to speculate. I mean, just generally speaking,
Yeah.
the office of sheriff is a constitutional office, not a statutory office. So
Yeah.
you don't really, honestly, it's very strange, and I don't like it, but you don't have to even have a peace officer's license to be the sheriff or the constable.
That's true. Yeah.
So how that goes with the Texas Commission on Law Enforcement, I mean, the people of Clay County, you know,
But you're elected official.
yeah,
That's what.
so statutorily, there's,
I don't
There-
think he's automatically disqualified.
I don't think,
Okay.
now you
Has to
can,
be
there's
removed.
some stuff in the administrative, was 87, removal of public officials, you can file a petition under, I think it's 87, don't quote me on that, Local Government Code 87, I'm pretty sure that's right, where you can go in there and file a petition to have an elected official removed.
Yeah.
But just like an automatic, oh, you got convicted, you have to go pack your office? No.
No,
I don't think so.
And plus it's a misdemeanor.
It is.
Even a
It
felony may not.
may not. I don't know. You remember that guy down there in LaGrange punched Marvin Zindler in the teeth right out there on Highway 71 and got reelected.
Yeah, I know.
So
strange
there's that.
stuff. Strange stuff.
Can't remember that old guy's name, but they made that movie about him.
Well, yeah, I mean, you hear about stuff like that, you know, people stealing, embezzling money and stuff.
Sure, well.
Get reelected, all that stuff, so.
Right. Well, this isn't that. Nobody else
I'm
has
trying to
anything?
conflate it, so, okay.
All right. Well, I really appreciate you guys coming out, and those of y'all watching live on the internet, I appreciate that too. And thank you guys for coming. If you don't have any more questions, I guess have a great day.
Thanks.
All right.